The Hunter Community Legal Centre would like to acknowledge that this community legal education presentation was made with the assistance of Boost Our City Community Sector grant from City of Newcastle.
Before we begin, I would like to acknowledge the traditional custodians on the land on which we are, and I would like to pay my respects to elders past, present, and emerging, and acknowledge that this land was and always will be Aboriginal land. I also acknowledge any Aboriginal and Torres Strait Islander participants who may be present with us today, and I welcome everyone. And just to give you a brief idea as to what the Hunter Community Legal Centre is, the Hunter Community Legal Centre is a free legal advice service. So we provide free legal advice and information to anyone who lives and works in the Hunter region. So our region actually extends all the way from the north of the Central Coast right up to Forster on the coast, and inland we extend all the way up to Cessnock in the lower Hunter and Mararundai up in the upper Hunter. So we do cover a big portion of the Hunter region. This information that I'll be providing here is not supposed to be taken as legal advice because everyone's circumstances differ from each other. So this is only for information purposes. And if you or any one of your clients has any issues relating to this, they should seek legal advice for their own circumstances. Just want to let you know that this is also present as on today, all the information that is on the 1st of December, and it relates only to New South Wales laws. So if you have anybody who has an issue with maybe a will or a power of attorney, which is outside of New South Wales or outside of Australia, then the laws of that state or country would apply. So they will have to get legal advice from a legal practitioner in that jurisdiction. Yes, and I will also at the end of this send a copy of these slides. I will also send some resources with regards to people you can, like links in this slide itself to maybe the trustee and guardian, so you can get information online as well as our information online. From here, we move on to wills. Now, this is something that affects us as well as the clients that we work with. So it affects everyone at large. Is what is a will? I'm sure everyone must be aware of what a will is. Some of us may have wills and some may not have wills as well. And it's never too late to make one if you don't have one. Same with your clients. You can always let them know that if they are worried about their property, they can always make a will. And it is a good thing to have a will. The reason why I'd like you to let your clients know that it is important to have a will is because, first of all, their property and their possessions, that would be their house, their the hard-earned money from all of their work, their superannuation, all of that has a way in which it will be distributed if there is no will. Now, if there is a will, you will have specific beneficiaries, and what you can do through that will is make sure that all of your property gets equally distributed to everyone in your family according to the way you would like it to be distributed. Now, that is very important for them to understand because if there is no will, it'll get distributed amongst maybe their children or ex-spouses who they would not want to have a part of their property of. So that is something that you would not want. Apart from that, if there are no known beneficiaries, it can also go straight to the government. Now, the last thing we want is for people to have their property go to the government. Another problem here is there is a chance that if there is no will, or there is a will that is not properly done, it will get contested in court. Now, when it gets contested in court, I think, according to me, it's like, really, do I need to worry about it? Because, I'm dead. So I don't have to worry about who's going to fight over my property. But think about it. Okay, when someone's contesting your will, they will pay for their solicitors. But for the person who has to protect your property, all the fees that are being paid to a solicitor will come out of your estate. So there again, you do not want lawyers to be enriched with your property.
Exactly.
Right? They're the last ones you want to become more richer, right? So these are things that we would like you to keep in mind, especially when you see that people that you work with do not have a will. Some people do have a different idea of a will. So what they would do is they'd have something called as a living will. Now, with the living will, I don't know if anyone has heard of a living will. Has anyone heard of it? Yeah. So, and this has happened with a friend of mine. Her mother took her sister and her on trips to small islands. They'd spend some time together. So effectively, her mother would have the support of both the daughters, as well as the daughters would have a little vacation. So it is another way of making sure that her money goes towards her two daughters, but during her lifetime, and they can all enjoy some time together. So a lot of people do make living wills in that sense. But at the same time, you would like to leave some residue for maybe another grandchild or a great grandchild. And at that time, it would be very necessary that a will is made. Okay. Now, when making a will, just remember that a lot of people do have this notion, and like even I would love to save a lot of money on making a will and make it as simple as possible. Get a will kit from the post office, make one, because it's ultimately going to be in my words. How wrong can I be, right? The problem is if you do not see the complexity of how your property is going to be divulged. So if you do not know how the complexities of how the organizations work, like the banking institution or your super fund, then effectively your will become null and void. So you have to make sure that there are a few formalities that are done, as well as your will is well worded. And for that, you need to make sure that it is in writing. It can be handwritten and it can be typed. The thing with handwritten wills is you have to make sure that your handwriting is really good, very legible, and in a good pen. Preferably not a fountain pen that we used back in the day, because if it gets wet, you know how that works. It needs to be signed and it needs to be witnessed. Now, someone who witnesses your will be the person who will say, yes, I have seen so and so person sign this will, and they will sign against it saying that, yes, I have seen this person sign the will. So all of these requirements have to be fulfilled, because if not, then straight out the will is declared as null and void. And then if it becomes as good as not having a will at all. So to avoid all of that, it is better to get proper legal advice before you make a will. If you feel that there are some complexities with the people that you're working with, suggest that you can get in touch with free legal services. We are a free legal service. We don't make wills, but we can always advise them as to what to do. The University Legal Center has legal workshops, will making workshops, so they will definitely be able to help you out as well. I will put all the contact details in this slide before I send it out to you all. Salvos used to make, I'm not too sure if they still do it. They used to have wills workshops, but ever since COVID, a lot of things have changed within the entire industry. But I will still check and let you all know about that, because we do not know about what they will be doing for the future.
Rita, just for our Wesley Mission volunteers, that Wesley Mission works with a couple of solicitors,
Okay,
and
that's good.
we have wills days where they pay a nominal fee. I think it's under $100 to get their wills written up.
Oh, that's amazing.
Yeah, so Turnbull and Hill. But when that comes up again next year, I'll let all our volunteers know, and then they can make their own decisions about if they don't have one or they need to alter it or something like that.
Yeah.
It's only a very small cost, because
that's really good. That is really good. Because so what you can do is you have someone here, so it is always best to get legal advice now that you know that there is someone who will do it for a nominal charge. Dawn, do they also do powers of attorneys and guardianship?
They did. That was a separate cost, but but it was very reasonable in comparison to what the whole lot would have cost.
Yeah, absolutely. I can totally understand it. And that's a really good service that they're doing. So yes, if you, and would that be only for the volunteers, or will it be for the person that you'll work with?
No, any of the people that we visit, any of our volunteers and any of the staff.
Okay, perfect. Excellent. That's great to know. So they will guide you as to where to sign, how to make the will, and if there are any complexities, what you can do to avoid those complexities. That's a good thing to know. Now, there's one more thing that is very important to know is how long ago you've made your will, or if you haven't made a will at all. Now, as we said, if you don't make your will, this is what will happen. It will get divided as per government formula. It'll get distributed to family members that you possibly don't even like anymore. That's the worst thing. And worse still, it could go to the government completely. So to avoid it, A, have a will. B, check when was the last time you made a will. We strongly suggest that at least every 3 years, go back to your will and check what you have done in that will, because a lot of things change. Okay, so when I'm saying a lot of things change, it could be the birth of a grandchild, another child, a great-grandchild, and the more additions to our family, the more our heart grows fonder for these little ones. So you want to save some money for them, for their future. You might put it in a trust. A solicitor will be able to help you out in building that trust and making that trust and appointing a trustee for that trust. Marriage and divorce. Strongly suggest that you revisit your will and make sure who you have last put as your beneficiary, because it could be an ex-spouse, and believe me, you do not want to revisit that one. Another thing is changes in relationships, and changes in relationships are exactly the same, in the sense of not just marriage and divorce, but it could be with your executor or any of your beneficiaries. So maybe when you have appointed an executor, and that executor passes away, or the executor moves away from the country and can't make it back to execute your will, you might want to consider having another person appointed as an executor. So for that, it would be good to go back to the solicitor and let them know that so-and-so person I had appointed as an executor is no longer alive or no longer in the country, or maybe I'm just not as close to that person anymore, or I don't have the same level of trust as I had with them earlier. So a lot of things can change like that. Same with your beneficiaries. You may have given half your property to your son, half to your daughter, but over the past 5 years, a lot of things have changed. Maybe your son has become the CEO of a company, or the daughter has become the CEO of a company, and the son has lost his job, and he needs the money more. So there's a change in relationship here, and you'd be like, okay, well, this is what I need to do. I might need to change it and make sure that my son has more money than I do, than my daughter, because she is well-to-do and he isn't. In such circumstances, you would like to revisit your will and make sure that you change all of it. Apart from doing changing all of this in your will, you would also want to make sure that there is a statement of wishes, and your solicitor will always tell you how to make a statement of wishes, making sure that you have stated why you want to exclude someone from the will or why you want to include someone in the will. Because you might have a nephew or a niece that you want to include in the will, and your children might go, but why is this person included in the will? So in that circumstances, you would want your will to explain why that person has been included, so that if at all it is contested in court, there is a proper explanation for it. Now, before we get into what kind of power of attorney we're talking about, does everyone have an idea that there are different kinds of powers of attorney?
Yep.
Yeah. So I'll just tell you the basic difference is between a general power of attorney and an enduring power of attorney. Now, just to exclude all of the confusion around it, is a power of attorney in general is something that you make to entrust the authorization to another person to make financial decisions on your behalf. Now, during your lifetime and before you lose capacity, you have an option of making a general power of attorney. And that could be for anything. You could make it for maybe while you are traveling around all of Australia, you leave your home back in Newcastle and you feel that you could rent it out. So you could rent it out and have someone in charge of the property to collect rent, to pay all the rates, bills, everything, and to make sure that the property is kept well. So that would be a general power of attorney that you would give to someone to do a particular task, a financial task. That comes to an end once the task has been completed, right? So that'll be a power of attorney that you're giving for a specific reason. Now, you could also have, say, been bedridden for a period of time. And for that period of time when you're in hospital, you would like someone to make sure that certain things are taken care of. That again comes to an end once you are out of the hospital and once you're back in action and you feel like, okay, I don't need to entrust this to so-and-so person anymore. You can cancel the power of attorney. Now, these are all general power of attorneys. But an enduring one is a little different because you are entrusting someone with an authority to make financial decisions on your behalf when you are alive, but when you have lost capacity to make those decisions for yourself. And when I say capacity, I mean the capacity to make any kind of legal decisions and financial decisions. So this could be decided by your solicitor in conjunction with your medical professional, who will say that, okay, this is a person who now has, say, a certain kind of mental illness and is not lucid enough to make a rational decision for themselves. And hence, this power of attorney will then come into force, where the person who is entrusted with that task to take care of all your financial decisions will then start making those financial decisions for you. So effectively, this can go on for a very long time. And you have to make sure that the person you are appointing is trustworthy. Now, when can you make that decision? It's only before you lose capacity. So So be very sure that a power of attorney can be made during your lifetime, but before you lose capacity. So if you are making an enduring power of attorney and you have already lost capacity, you cannot make an enduring power of attorney, because making that decision itself is considered as a legal decision, and you would be considered as not having capacity to make that decision of entrusting that financial decision, the authority to another person. So make sure that an enduring power of attorney is made before the person loses capacity. Now, what can a power of attorney basically do? A person can do so many things. So this is again something that we stress upon very strongly, is make sure that this is a person you can trust, and not just trust in the sense of the person may do something dodgy. It's also trust in the sense of whether the person is capable of doing it. So it's not only the person has to be over 18 years of age or be trustworthy, but also have the ability to do it. If you're going to entrust someone with financial decisions and the person has no clue how these things have to be done, you are basically making an error of judgment by entrusting all of these powers with that person. That person is going to be so overwhelmed that they cannot handle it and they would have to take further help. So you want to make sure that this person who makes the decisions for you makes it with proper consultation and acts purely on your behalf in your interest. So you can see here, they can operate your bank account, they can pay your electricity bills, your nursing home bills, but they cannot decide which nursing home you can go to or what kind of medical decisions. For that purpose, we will get to the enduring guardianship, which is purely for medical and lifestyle reasons only. Okay, so there is a clear-cut distinction here between what kind of decisions a power of attorney can do and what a guardianship can do. So there are two different kinds of powers they are giving to one person. So you want to make sure this person has ability to do it, has the is also does also have the capacity to do so, and is over 18 years of age and absolutely trustworthy. The thing the person can't do is, of course, make consent on your behalf to get married, consent on your behalf to vote, or make any kind of medical or lifestyle decisions for you. Now, a power of attorney actually is made in a form. So there is a specific form for that. And your solicitor will be able to take you through the form. It's very simple, and you have the you have full authority to make these decisions as to what kind of power you want to give your attorney. So you can be very specific about what you want, or you can give them a general decision to make, general power to make a decision on, say, your bank account or any of your shares or real estate. The reason why we say that the person has to be trustworthy is so that you make sure that the person keeps all your financial interests separate from their own finances. So you have to make sure that this person keeps a proper log of what they are doing with your estate. Make sure it's kept completely separate from their own estate and from their own finances, so that there is no mixing and no question with regards to the trust that you have given them. So you can also specify what you would like the attorney not to do. So there are two sections where you can limit their powers. There are two sections. One is what you can give and what you can limit. So you can give them all these powers and you can limit them from doing certain other things. So your solicitor will be able to then take you through it and ask you all these questions. So when you're going to a solicitor, make sure you give them all the information that you have with regards to who you're appointing and what you're appointing them for. If at some point of time you feel, again, this is like a will, so you have to go back to it every hopefully less than 3 years, because it's a very important document. You're giving someone, you're entrusting your property to that person and make decisions on your behalf. So you would want to visit that every now and then and make sure that the person you have entrusted with this authority is still capable of doing what you have entrusted them to do. So again, if the person has passed away or the person no longer lives in the country, no longer lives in the state, or you basically just have the relationship has fallen apart and you don't have the same relationship, you can always cancel that power of attorney. And this is exactly how you would like to do it. First of all, let the power of attorney, that is the attorney, know that you are canceling their powers so that they know and they don't act upon it later on. Because if you don't tell them, they will still be under the impression that they have the power to act on your behalf. So make sure you communicate to them. You can do it through your solicitor, which would be a good thing because you would want to keep a copy with your solicitor as well. You would want to keep a copy with your attorney. You would also give a copy of your power of attorney to the bank because they would be dealing with your finances. Possibly even your securities account. So if you have maybe an agent who manages your shares and your property, then you would like that person to also have your a copy of your power of attorney. Now, first things first, let the attorney know that you're canceling the power or you're changing the power of attorney. Secondly, go to all of these authorities that you have given a copy to or which the attorney has authority over, and let them know that you have changed the power of attorney, just to make sure that it is not misused or accidentally used. And thirdly, destroy it once you have changed all of it. Destroy the old one, make sure the new one is in place with everyone in the same manner. Keep the original, give copies to everyone, and make sure that it is signed like how you would do it with a will. So this is with regards to a power of attorney, straight to enduring guardianship. Now, enduring guardianship is very similar to that of an enduring power of attorney. It's again a form which you fill up and it's documenting all the powers that you would give to a guardian, just the way you would give an attorney and a power of attorney. The most specific difference is that power of attorney is only for financial and real estate purposes, but the guardianship, as I had said, is for medical and lifestyle purposes. So this is it. Your guardian can basically make any decision on your behalf with regards to your health and your lifestyle, but only when you lose capacity. So before you lose capacity, you can make those decisions for yourself. You can make a power of attorney, an enduring guardianship to entrust that decision with someone you trust with your life, and that person will make those decisions on your health and your lifestyle. When you pass away, this power of this enduring guardianship comes to an end. Or if the guardian passes away, then it comes to an end. So again, then you will have to make a fresh one, or you'll have to change it up. So when we are talking about making health decisions, we are talking about deciding where you want to live. So say whether you are capable of living at home, or would it be necessary for you to live in a facility where you will be well taken care of based on your specific needs. So again, you will have to make sure that the person you are appointing can make all those decisions. Or you make sure that the person can consult with a medical professional about making these decisions as to where you could and should live. Also, with regards to the support services that you would need when you're living either at home or in a service or in a home, whether you will get that proper assistance or not, they will make that decision for you. So you can be specific about which a retired facility or an aged care facility you would like to live in, and mention that in your in your enduring guardianship. Please pardon me because I just kept saying so much about the power of attorney. Now it keeps I keep repeating it over and over again. So yeah, the support services that you will need, that can include personal health, even health for your home, just everything that comes within aged care packages, stuff like that you will need. Medical and dental appointments, you would need someone to take you there, book appointments for you, make sure about what kind of medical treatments you would like. Now, in this, I would like to actually highlight that you can also have an advanced care directive added to your enduring guardianship. Now, has anyone heard of an advanced care directive?
Yeah, Mum's just done one.
Okay, yeah, there you go. So an advanced care directive, sorry about that. An advanced care directive is a document, again, which is very specific about what kind of medical treatments you would like. So say, do not resuscitate, or if you want to make an organ donation, then you would like to register with the organ donation. I think there is a organ donors registry, and you can add that to your enduring guardianship as well. So take all this information to your solicitor, and your solicitor will be able to then make proper directions in your enduring guardianship. So there will be a reference to it, and you will also make sure that your advanced care directive is specific about what it says and what kind of directives your medical professional would need to have. Well, you can now connect it to your My Health record as well. So you can have your advanced care directive right there for all your medical professionals to have a look at. So that can, yeah, so that makes it a lot more easy in that sense. The thing with enduring guardian is a lot of people anticipate that there will be a lot of family feuds. Mm-hmm. So and this can happen to the best of us. One sibling will make sure that the other sibling doesn't come and visit mom or dad. The most classic one, we've had several cases with that happening. So again, you want to make sure that when you're giving that power to a certain person, you can also limit those powers. Yep. So yeah, so that's again something you would want to speak to your solicitor about and make sure that all of this is in check. And please revisit it so that you can make sure that all of the changed relationships are also taken into account. Now, as we have said, in a power of attorney, even a guardian needs to be over 18, must be willing to take on the role, must be someone who will act in your best interest. And so this is more than finances. This is your lifestyle. This is your dignity. So you want to make sure that the person who makes all those decisions for you makes it appropriately and in your interest. Yes, and with regards to carer allowances, again, make sure that you check with your solicitor or you check with Centrelink as to what allowances they are eligible for before you make them, because they will be taking a lot of, they will be incurring a lot of financial expenditure because of this. So you would want to make sure that they're willing to take it on and they have some way to be financially reimbursed. Again, as we said, and like a will and like a power of attorney, even an enduring guardian needs to be revisited every now and then, as I have said, because relationships change, people change, circumstances change, a lot of things change in the bargain. And I think we've seen the biggest changes happening at this time in this year itself. A lot of people have lost family members, have been kept away from family members for public safety. So there are a lot of things that changed over a period of time. And we can't always have those unforeseen circumstances being taken into consideration. but the ones which you can keep in check, like changes in your relationship, or making sure that your guardian is still willing to take that role or is still alive to take that role, you might want to make sure that all of it is in check. If not, then you always have an option to cancel an enduring guardianship. First is if you still have capacity, but again, you have to still have capacity, not once you have lost capacity. So all of this can be done only before you lose capacity. So if you already have an enduring guardianship, you still have capacity, you can change it right now if you need to. All you need to do is get this done by filling out a form with the New South Wales Civil and Administrative Tribunal. There is a guardianship division. You can get legal advice before you make those decisions and then fill out a form. Secondly, if you have lost capacity, NCAT will then make a decision about cancelling. So they will make it separately about cancelling your enduring guardianship once you have lost capacity. And that obviously another form has to be filled out. So the guardianship division will decide upon your guardianship there. If you have married, this is again another issue here, is once you marry, your spouse would like to be your guardian. And so if you have someone else who has been appointed as your enduring guardian, make sure that the person has been informed of your marriage and inform that person that you would like to cancel that guardianship, and make sure you destroy all the copies. And we do provide assistance and legal advice on civil and administrative tribunal matters, so you can always get free legal advice. You also have a solicitor, but I'm not too sure how it works, but nevertheless, you always have an option. You always also have an option to call up the Civil and Administrative Tribunal for any kind of information that you may have, but they will not be able to give you legal advice. So if you need some legal advice, you would have to contact a legal professional for that. And it's always worth getting your matter checked by a legal professional before you make this make an application to the Civil and Administrative Tribunal. A solicitor is not allowed to represent anyone in the NCAT. So generally, you would be self-representing. So you can always get prior legal advice before you represent yourself in the Civil and Administrative Tribunal, because it's fairly casual. It's not very formal like a big court. So that makes it easier for lay people to argue for themselves. What I'm going to do in this as well is I'm going to put in more links and help you all with some referrals. So right now I have got these 2 links. I will put some links in your local areas as well, because there are, just like the Hunter region, there is a community legal center in the Central Coast as well. And they also have, I think they have like an older person's advice line. But I will put all of those links in this slide, and I will send it over to you before you all can. So at the click of a button, it'll take you straight to the website of each and every service, and then you can get proper legal advice from them. If any of y'all use social media, please feel free to like us, follow us on all of these mediums.
The Hunter Community Legal Centre would like to acknowledge that this community legal education presentation was made with the assistance of a Boost Our City Community Sector grant from City of Newcastle.